In this lecture, we're going to focus on constitutional limitations and our rights as they are listed in the Bill of Rights and within the U.S. Constitution. Your book gives a really great in-depth review of the different rights and safeguards that protect us. But in this lecture, I'm going to review just some of the most important and the most wide-reaching. We're going to begin today's lecture with a review of our governmental structure and its impact on the limits imposed on the formation and the application of criminal law. To begin, we have to discuss the formation of our government. As you are aware, breaking away from the British Empire during the Revolutionary War allowed us to leave the monarchy that was set up there. Fed up with being ruled by a central figurehead, our founding fathers created a constitutional democracy. This was meant to protect the rights of the individual from the whims of a tyrannical government. In this case, we mean the monarchy. But part of a constitutional democracy is making sure that the government is stable in the formation of law. The laws have to be specific, clear, and they have to be disseminated well to the general public. One of the things that we talked about last time is that the citizens are not responsible for their actions if no one has told them that those actions are illegal. How do I know what the speed limit is on a particular road if there's no sign announcing the speed there? The laws also can't change on a whim. We need to make sure that the laws are constant and steady, don't change in punishment, and don't change in scope every other year. However, when changes do take place, they have to remain within the scope of our constitutional limits. One of the biggest safeguards that we have regarding new laws is the idea of ex post facto. Ex post facto laws are illegal because you cannot retroactively punish someone for an action that was legal at the time that it was committed. In other words, you cannot pass a new law on Friday and apply it to everybody who committed the action on Thursday. When laws are criminal in nature, there are a few limitations in regards to what is permissible and what is not. The first in the scenario is just as I described. If I committed the crime before the law was passed, then you cannot prosecute me for it. The same goes for aggravation of a crime. If you change the law to make it greater or more serious in nature, then I'm still free from prosecution under the new terms if that was not the way that things were in place at the time that I committed my crime. It's also illegal to make a punishment harsher if the law called for a more lenient punishment at the time of my offense. Finally, it is illegal to alter the rules of evidence and have them apply retroactively. If a certain crime were to require mandatory DNA evidence, you cannot require that of me if it was not a requirement previously. But let me pose this question to you. What would happen if the law is retroactive in a positive or in a lessening direction? Do the same safeguards and restrictions apply in that sense? Is that even legal? Or does it violate the ex post facto clause even so? Let's speak for a moment about the Supreme Court case of Furman v. Georgia. You may have heard of it as it is a landmark case because it ruled that the death penalty for a time was unconstitutional in the United States, given the variety of problems embedded in the sentencing process. The court ruled that the use of the death penalty violated the Eighth Amendment, which protects us against cruel and unusual punishment. And it said that it required that the federal government put a de facto moratorium on capital punishment. States were required to comply with this moratorium. The problem was that states had hundreds of people sitting on death row. So what do you do with all these individuals that have already been sentenced prior to the moratorium? The solution was really to start commuting sentences. When the court made the ruling that the death penalty was unconstitutional, all of the death row inmates were essentially shifted to a life without the possibility of parole or life with the possibility of parole, depending on the individual. This is certainly an example of a retroactive application of a law, but is it a violation of ex post facto? The answer really is no. In order for ex post facto to apply, the law has to be punitive in nature rather than positive, making things less punitive for those in question. In addition to limiting the ability of laws to be punitively retroactive, we also want to make sure that our laws are as clear as possible. When you create a new law, you have to be clear so that it is not open for bias or unnecessary interpretation. If I can't understand what specifically is being outlawed, then this probably isn't a very good law. If you look at codified law, those statutes are so specific and so well defined that it's very difficult to find a loophole around them. That's done purposely so that it is very easy and very routine to prosecute individuals for certain crimes. But what happens when it's not clear? Laws can be struck down for being void for vagueness. In order to be declared void for vagueness, laws have to meet 3 specific criteria that you see on your screen. First, anyone should be able to understand the law. Young or old, everyone should be able to figure out that a speed limit of 55 miles per hour means that you should not be going 65 without running the risk of a ticket. Secondly, there has to be uniform enforcement. This means that if 3 of us were speeding and we all got tickets, then all 3 of us should be getting tickets for the exact same amount. And finally, the law needs to stipulate that if there is a punishment involved, what is the specific criteria needed to meet that punishment? This protects us from the government being able to send us to prison for 20 years for something as simple as shoplifting. I briefly want to discuss an example from your book talking about this idea of statutory clarity. Nebraska v. Metzger. In this case, Mr. Metzger was convicted in trial court for violating a Nebraska ordinance which prohibited individuals from engaging in anything that was indecent, immodest, or a filthy act that was committed in the presence of another person. So one morning, a neighbor was parking his car on the street at the time of this event, and he stated that he saw Mr. Metzger in his apartment eating cereal while he was naked. Metzger was visibly naked from the thighs up. The event took place for a period of about 5 seconds, so real fast. He wasn't out on the street. He was in his house standing in front of a window. He was not making any lewd gestures, and he was not interacting with anybody else. The witness called the police, who also witnessed the man eating cereal naked, and stated that because Mr. Metzger was only a foot from the window while he was naked, it would be likely that somebody would see him. The ordinance was ruled by the Nebraska Supreme Court to be unconstitutional because it was void for vagueness. Remember what I said before. The behavior had to be immodest, indecent, or filthy in nature. Well, that's very subjective, isn't it? Something that I might find indecent, it might not faze you in the least. It violated due process portion of the law that stated that criminal statutes must be clear and they must be definite. Equal protection and due process was strongly established in 1865 after slavery was abolished during the Civil War. The 14th Amendment provides for protection against imprisonment and other penalties without first requiring an individual to go through the trial process properly. This amendment accounts for equal protection in regards to race, age, gender, financial status, and even the elderly. In other words, everyone should be treated the exact same way. Even though the 14th Amendment was ratified in 1865, the enforcement of it was actually pretty rare. Simultaneous to the 14th Amendment, we were operating under the ruling of Plessy v. Ferguson. This case established that races could live segregated from one another, provided, of course, that things were separate but equal. From that court case, you saw things like black and white water fountains, black and white entrances to buildings, and even black and white sections of public transportation. In 1954, the SCOTUS overturned the Plessy ruling when they decided in the case of Brown v. Board of Education. The SCOTUS recognized that separate but equal is unconstitutional. This paved the way for school integration and is the foundation of the civil rights movement as we know it. However, despite the decision, the path to integration did not go very well at all. One of the biggest issues arose in Little Rock, Arkansas, and involved what we now know the group as the Little Rock Nine. The Little Rock School District was making preparations for racial integration in the schools. When the school year began, 9 high school students who were black were denied entry to that high school. The governor of Arkansas brought out the Arkansas National Guard to help deny the students entry. At the time, President Eisenhower tried to de-escalate the situation, but when that didn't work, he was forced to send the Army and also had to federalize the National Guard, which essentially took control out of the hands of the governor. Eventually, the students were allowed entry through the school, and thus began racial integration in the South. But even though the 14th Amendment does provide equal protection, there are still a few exceptions that allow for differences to be taken into account, provided, of course, that there is a very strong governmental interest for these differences to exist. We begin with the rational basis test. This allows for laws to recognize things like age, poverty level, and elderly status for the justification of differential treatment by the law. If you think about it, this really makes sense. We want to put some limitations on individuals based on age. Think of a few examples here. There are age limits on driving, drinking, military service, voting, and even gambling. There are also limitations on income level. Right? So if I make $100,000 a year, and I don't meet the threshold for food stamps, nor do I meet the threshold for government-assisted living. There's a strong governmental interest in keeping these separations in place. Strict scrutiny is a little bit tougher to try and interpret if you're the government. This states that you can only signal out a racial or ethnic minority for differential treatment, but it has to be strictly necessary and there can be no other alternative put in place for the law in question. Most often, strict scrutiny is really used to overturn racially unbalanced laws rather than to put them in place. So we go back to our previous example of racial integration. There's no reason for people of different races and ethnicities to not interact in the same places. Strict scrutiny was also used to overturn laws outlawing interracial marriage, for instance. Finally, with the classification of intermediate scrutiny, there has to be some reason why it would be in the state's best interest to have laws only affecting one gender over the other. Many arguments for same-sex marriage are rooted in this clause by saying that gay and lesbian couples are not being afforded equal protection because they are not allowed to marry. This argument also extends to older issues such as inheritance laws, women in the military, and later on, women who were wanting to serve in combat. The government would have to have a very strong argument as to why there needs to be a gender divide within the country for certain issues. Equal protection is put in place to protect our due process rights, and this really extends through the rest of our constitutional rights and protections as well. Even though we have these rights, they really can be abused, and they often are, by people who feel as though they have the right to do whatever they want simply because the protection exists. The Bill of Rights was written more than 200 years ago, and the interpretation of these individual rights can differ from the original interpretation meant by the Founding Fathers. The courts can interpret them to make sure that they are finding their explicit and implicit meanings. We could spend an entire lecture really talking about and interpreting all of the legal precedent that applies to the Bill of Rights alone, but for the purposes of this lecture, I am going to focus on just two of them. Several fundamental constitutional guarantees ensure that we have a right to privacy. However, privacy is not a guaranteed right anywhere we go, and your actions sometimes can dictate whether or not there is a privacy guarantee. Interestingly enough, even though the Constitution does protect our privacy rights, we don't actually have a specific constitutional amendment that explains our right to privacy. Instead, privacy is really pieced together and embedded within the First Amendment, free speech, the Third Amendment, which protects against no soldiers quartered in the house, Fourth Amendment, protections against search and seizure, and the Fifth Amendment, which protects against self-incrimination. It is actually first recognized in 1905 when a pharmaceutical company used a man's picture in promoting their new miracle drug. The company didn't gain the man's permission first, and they actually used him to endorse the medicine. The court ruled that manufacturers cannot use our images to their advantage and they can't use them to promote their products if we don't agree, and therefore it violates our right to privacy. Our right to privacy is reaffirmed in the Griswold case in which a doctor is facing criminal charges under a Connecticut law that states that anyone who was found to have provided contraceptives to another person will be subject to a fine of $50 and they would be imprisoned between 60 days and 1 year, or both the fine and the imprisonment could apply. The doctor has no choice at this time but to give up his patient list, which included the Griswolds. They sued as a violation of their privacy rights as a married couple that was having a private conversation about their reproductive options with their doctor. This is really the first court case in which the court provides a really in-depth explanation as to what privacy is and how it's safeguarded. So we have to ask, what areas do our right to privacy extend to? We have the right to privacy within the sanctity of our own home, and the commission of any intimate activities and what we do with our own bodies. This extends, of course, to the use of contraceptives, sexual activity, and even abortion. Privacy rights also extend to our information, like social security numbers, bank account information, and other sensitive documents. Finally, I want to address the Eighth Amendment, or what we call the Corrections Amendment. The Eighth Amendment protects us against excessive bail, which shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. This means that we're protected regarding the methods employed to inflict punishment, the amount of punishment that is imposed, and even the prohibition of criminal punishments of certain acts. Most commonly, we discuss the Eighth Amendment in combination with the death penalty. We are actually going to spend time and address the death penalty again when we discuss homicide, but for right now, I just want to review a few things from a historical and evolutionary perspective regarding its use. If we think of things historically, we have to note that we no longer execute inmates the same way that we used to during the days of colonial America. We used to hang inmates. Then we had a couple botched executions because really the executioners did not set up the noose correctly. So that didn't work for us anymore, and we decided that we were going to move towards more humane forms of execution, namely electrocution. But that wasn't without its flaws either. The very first electrocution via the electric chair burned the inmate so badly you could actually see his spinal column. Inmates have caught on fire as recently as the year 2000, which was around the time that we began to switch to the use of lethal injection. Lethal injection has also been strongly problematic with the increase of inmates waking up mid-execution because the IV lines were not properly put in place. We have also used the firing squad and the gas chamber over the years, both of which were actually reinstated in 2015. But this brief history of the use of executions is important because it touches on the idea that if we are going to execute, the law requires that we do so humanely. And if there is a better way to do it, then that's the method we should probably use. The case of Trop v. Dulles states that it is important for us to maintain the evolving standards of decency. If we continue to deem the death penalty as an acceptable practice, then the implementation of it cannot be torturous and it cannot be lingering in nature. At this point in time, we are once again raising questions about the use of lethal injection and whether or not it is acceptable given the issues we've been having with the 3-drug and the 1-drug cocktail that are popular in many states that use lethal injection. In the summer of 2015, the SCOTUS will answer the question as to where the death penalty really goes from here. A discussion of the death penalty is not complete without the discussion of legal issues that surround it. We have already discussed Furman v. Georgia, but remember, this is the case in which the SCOTUS voids more than 40 death penalty statutes and suspends the death penalty. 4 years later, the Furman ruling is actually overturned with the CRIJ v. Georgia decision. In this decision, the court states that the death penalty can be reinstated, but there has to be a new process in place that includes a death-qualified jury, a bifurcated trial, and an automatic appeals process, among other safeguards to protect inmates' rights. Finally, we have to discuss 2 cases which touch on the appropriateness of using the death penalty when a homicide did not actually take place. In Coker v. Georgia, an adult woman was raped, but she did not die. And in Kennedy v. Louisiana, a child was raped, but also did not die. In both cases, the SCOTUS stated that the Supreme Court is not appropriate when the victim doesn't die. The court has also ruled that it is unconstitutional to execute the mentally ill and juveniles who are under the age of 18 at the time of their offense. We have to address such current controversial laws like 3 strikes or 10-20 life laws, which result in long-term punishments for potentially very small level felonies. California is actually the most notorious state for their use of 3 strikes legislation. California has incarcerated individuals whose third felony was just for the theft of $400 worth of golf clubs and for the theft of videotapes. They're very low-level felonies that are not dangerous or severe whatsoever. Many 2-strike offenders were actually leaving the state in case they got caught committing another low-level felony. For a while, there was an exodus to Oregon for a lot of individuals who were 2-strikers. In 2012, there was a voter-driven proposition which successfully changed California's 3 strikes laws to extend life sentences to only those individuals whose third felony was serious and violent in nature. As a recap, in this lecture, we focused on constitutional limitations and our rights as listed in the Bill of Rights and the U.S. Constitution. We discussed legal safeguards like ex post facto and statutory clarity. The lecture ended with an examination of our right to privacy and a review of the 8th Amendment. Remember that the discussion of the other amendments is found in your textbook, and we will review them in class. In the next lecture, we are going to jump into applying all of this foundationary material to the elements of different crimes. Thank you for joining me.